think that should be working.
Thank you. We can move to the next slide.
Great.
So in today's session, we will be covering some basic elements of the two, main tax effective structures that we see as family lawyers, being a company and a trust. Our clients choose these structures, often on advice from accountants, but not always, with a view to minimise or defer the payment of tax. We'll then go on to talk about some of the common income tax issues that arise in our practice, go through some key features of CGT and stamp duty, and then talk about the tax consequences of assets in a trust or SMSF. I guess the key thing to keep in mind as we move through the presentation is that as family lawyers, our job is not to advise on tax. We simply need to issue spot on behalf of our clients and bridge that sort of communication gap between what their accountants and advisors might tell them about their current tax affairs and then how these might change as a result of a family law property settlement. I'll hand over to Kat for the next slide.
Thank you. Thanks, Liz, and thank you, Dina, as well, for that lovely introduction. So before we launch straight into income tax, CGT and the like, we thought it would be helpful just to take a moment to recall the general features of a company and a trust, which make them attractive for tax planning purposes for our clients. So if you can recall corpse law from uni, which is a bit of a nice trip down memory lane, for me at least, we know that companies are separate legal persons. So this means if your client is an at-risk person, they can quarantine their personal affairs from those of the company by virtue of the corporate veil. So our clients largely deal in private companies with the suffix proprietary limited, which the 1936 Tax Act helpfully defines a private company in section 103A as, quote, not a public company. So, and then the Act also sets out what is a public company, which is much more complicated. So importantly, if under section 103A, subsection 3, subsection A, 20 people or less have the right to at least 75% of the value, voting power or dividends of the company, then it won't be a public company. So this brings in most of our clients and their companies, and person is defined as the controlling mind. So in addition to being private, these companies are what's called limited liability companies, which means members are not personally liable for the company debts. And therefore it offers limited liability protection for its shareholders. So this is useful if the company engages in risky business activities and to protect private wealth of individuals. You'll recall companies are taxed at fixed rates of 25-30%, unlike individuals who vary more widely with marginal tax rates between 16, 30, 37 and 45%. Companies also allow for the retaining of profits, which is helpful. This allows for the tax-effective use of profits and reinvestment into the company. This is, of course, different from a trust, which I'll speak to in the next slide, that needs to make distributions of income each year, failing which the trustee will be subject to tax at the highest marginal rate. And companies also have the benefit of franking credits, of course. So franking credits refer to part of the dividend imputation scheme that we have in Australia, which essentially allows Australian resident taxpayers to claim a tax offset for a franking credit attached to a dividend or distribution. In essence, it's a ridiculously complicated scheme and a whole other separate topic in and of itself that we will not broach today. But essentially it allows for recognition or a credit for tax already paid by companies to prevent double taxation of the same income by both the company and shareholder upon receipt of that money. So as we move through the topic and talk about this topic, keep in mind that you can only really get money out of a company in one of two ways. And this is really important. So one is that the board or members declare a dividend, and the other is you can borrow it, like a loan. So the massive difference here is that dividends will be subject to further tax in the hands of the recipient, whereas a loan, at least until Division 7A was enacted, does not. Next slide, please, Dina.
I'll have to make our next webinar on franking credits.
Liz would love to take that one. A whole other topic in itself. Yes. So, okay, thank you. Now we turn to trusts. So a trust is not a separate legal person or entity, unlike a company, and it cannot sue or be sued. So a trust is a relationship in which the trustee, being either a natural or corporate person, holds assets on behalf of a class or classes of beneficiaries. So in family law, we know that it's the appointer who holds the ultimate control in being able to replace the trustee if desired. So as family lawyers, we deal probably most often with discretionary trusts, of course, where legally no one beneficiary has any proprietary interest in any trust property. And the trustee has discretion as to how assets or income are distributed to eligible objects of the class or classes of beneficiaries. We also know that for family law purposes, generally speaking, if a party conducts a trust entirely within their family, the court will treat those assets as though they are personally held for the identification, valuation, and division of property between parties to a relationship. So trust is what is really known as a look-through entity. It's not taxed itself, and this means we need natural or corporate persons who can receive trust income, and they become the relevant taxing point. So trusts allow for flexibility in income distributions to different beneficiaries, and they have better CGT concessions, which again, Dina, is a whole separate topic in and of itself, but in short, they're essentially the same as an individual. So how is money extracted from a trust then? So there's either a distribution of income to a beneficiary, and then the beneficiary is taxed on that income, or there's a distribution of capital where there is no tax. There are also concepts of present entitlement and unpaid present entitlement, which you'll be familiar with within a trust. These concepts will be discussed in a little bit further detail in a couple of slides when we're looking at Division 7A and UPEs to corporate beneficiaries in particular. And thank you. So the benefits of a company or a trust. So one of the main reasons for these structures and why your clients would use companies and trusts is, of course, the reason we're all here today, tax. So as we've discussed now at a very high level, they each have their different benefits and they work well, which can work well together. So for example, our client may only own half or a quarter of a business or may increase their interest over time by agreement with other business owners. And a company is perfect for this as new shares can be issued readily and cheaply. Shares can also be bought and sold easily. So if your family owns a business directly rather than owning shares in a business conducted through a company, you need to dispose of the trust itself in order to sell the business. This can be much more complex and less desirable than a simple share sale. Holding shares, however, via a trust of which a client is a beneficiary provides asset protection and tax planning flexibility. So what we often see in this space and working with our family law clients is the trusts and companies work together. So for example, we often see a company acts as a trustee of a trust, known as a corporate trustee. Whilst it may be the legally registered owner of trust assets, it holds them non-beneficially in its capacity as trustee of that trust and not in its own right as the company. Separately, a company or companies can also be the beneficiary of a trust, known as bucket companies, and therefore when distributions of income are made from a trust to a corporate beneficiary, it can pay tax at only the 25% or 30% rate. So this is advantageous when you compare it with the individual marginal tax rates if that income went to an individual. Next slide, please, Dina, and then I think I will hand over to Liz.
Thanks, Kat. So the idea of Division 7A comes up a lot for family lawyers, and I guess the idea is understanding at a high level what it is we really need to know, because you can't really talk about income tax without talking about Division 7A when you're dealing in the world of families and their businesses, and the same works in the reverse direction. So what is Division 7A? It's quite literally a division of the 1936 Tax Act, bearing in mind there are two acts. They tried to rewrite the 36 Act in 1997. They got, I think, halfway or 2/3 of the way through. It was such a mammoth task, it couldn't be completed, so now we have two. But essentially, this section of the 36 Act is really a complex set of anti-avoidance measures, by which we mean loopholes that the ATO doesn't want people to exploit anymore. It's designed to prevent profits or assets being provided or accessed by shareholders or their associates without proper tax being paid. So we saw, sort of 30, 40 years ago, a lot of accountants had the idea of using bucket companies or these corporate beneficiaries that Kat referred to in the previous slide to essentially freeze profits or freeze tax, I should say, on profits at a company rate and then allow the individual to help themselves to the company's wealth. So you'd pay your tax at 30% and then the company would buy the boat, the holiday house, all these assets that were absolutely not required for the company but were really personal use assets. And so what we see Division 7A doing is not so much being provisions that generate or trigger taxation, but they are deeming provisions. And they operate to retrospectively recharacterise a loan or just a general benefit from a private company and recharacterise those as deemed dividends. So importantly, a deemed dividend under Division 7A isn't the same as when a standard company pays a dividend to a shareholder in the ordinary course. So if you own shares in a public ASX listed company, that company pays you a dividend. That's what's called a franked dividend, because the company's been paying their quarterly tax bills for the company and being taxed on their profits at 30%. They then pay the shareholders a share of those profits that are commensurate with the shareholding. So if I receive this kind of a dividend, I include it in my tax return, and it gets grossed up, or kind of literally increased, multiplied by the 30% company tax that gets added to it. And I get a credit for the tax that's already been paid by that listed company. And then the whole amount is treated as part of my assessable income under Section 44 of the 1936 Act. So that process for receiving a standard dividend is one that we're all familiar with. But what Division 7A says is that it says to a shareholder or an associate of a shareholder, that money that you think you borrowed or you called it a loan from your company, or often it's from a corporate beneficiary, money that's been distributed to a company, that money that you think's a loan is actually something else entirely. And the process of this deeming is one in which the Commissioner essentially says that money forms part of your assessable income at your personal marginal tax rate, and we don't care that the company has already paid tax on that amount. And that's why we call it an unfranked dividend. So the point being made on the slide is that deemed dividends are essentially given penalty tax treatment because they are treated as being unfranked, which means no recognition of the tax already paid by the company. It's not the case that loans are entirely off limits, but rather if you want the tax benefit of borrowing the money from your company or your corporate beneficiary, instead of kind of stripping it from your company improperly, then it has to be a genuine loan and has to comply with Division 7A. So it has to look like, seem like, smell like, be like an actual loan. So we need a written agreement that's compliant with Division 7A. We need repayments of principal and interest. And we need, like any genuine loan, a time frame for repayment that is reasonable. So 7 to 10 years is what's provided for in the Act if it's unsecured, and that's the most common, or 25 years if it's secured and at least 110% of the loan value. In the same way the bank would assess a loan-to-value ratio, we do the same. Many of the resources out there on Division 7A try to explain the concepts of a payment, a loan, a debt forgiveness, what's a shareholder, what's an associate. Each of these could be an entire subject of themselves, and to be honest, it's probably well beyond what we as family lawyers would need to know. I think the take-home point is they're ridiculously wide definitions, and they usually catch everything. And if you have a question about that, asking an accountant, asking an expert is obviously the way to go. One thing to note is that former spouses, ex-partners, are generally excluded as associates because there are special rules that apply, but I would suggest you still have to be careful. As family lawyers, we're most concerned with loans because this is how people often structure the deferment of their tax. I've summarised the definition from Section 109D3 of the 1936 Act on the slide for you. And you can see it's basically a sniff test. So an advance of money, provision of credit, or any other form of financial accommodation, payments with a repayment obligation, any transaction which in substance affects a loan. So we have here, if it smells like a loan, the ATO will require it to be properly treated as a loan or will deem it as a dividend. What's a UPE? Why do we care? UPE is an acronym that stands for Unpaid Present Entitlement. So the idea of present entitlement is a tax concept to allow someone other than the trustee to be assessed on what's called the net income of the trust estate. And what we need is to make someone, a natural or a corporate person, presently entitled to trust income before midnight on 30 June in any given financial year. If someone, whoever is made presently entitled to that trust income, will then be assessed to pay tax on that income. And that's regardless of whether or not they receive it. In fact, and we see this a lot as practitioners, they often don't receive it because it's already been spent. The one exception to that is that a distribution of this nature can be what's called disclaimed. But for the most part, if you've been made presently entitled to that income, then you're the one who's taxed on it. So UPEs, or unpaid present entitlements, arise when someone is taxed on the distribution of trust income but doesn't actually receive it. And we care about UPEs because the ATO has said that UPEs are a financial accommodation, going back to that earlier definition, and that's a relevant loan under section 109D3B. So to avoid a UPE being deemed as a dividend and taxed in that penal way that we were speaking of earlier, you need them to be repaid as proper loans. What's special about the 16th of December 2009? Sometimes you see this date recorded in books and records pre-December 09. Basically, that date was the commencement of this section of the Act, and any UPEs before this date are effectively frozen and don't need to be repaid or dealt with. Moving on to the topic of income tax, we're not going to talk about the different tax rates here. You can find them readily available. Just know that the two lowest brackets above the tax-free threshold changed in FY25, in the most recent financial year, from 19 cents and 32.5 cents respectively to now only 16 cents and 30 cents. And these are all available on the ATO's website. Instead, I thought we could focus on some common scenarios in which additional income tax needs to be factored into a balance sheet for property settlements. So, PAYG withholding and instalments. PAYG withholding is a simple and effective system for collecting tax in Australia, where employers withhold tax from their employees' wages. So if you act for or against someone on the PAYG withholding system, it's unlikely that you would need to worry about a large tax bill or indeed a large refund for tax on income, unless there's some very significant deductions, because the withholding system kind of keeps people at the right rate at all times in the year. However, if you act for or against someone on the PAYG instalment system, this is where businesses or individual taxpayers make regular prepayments towards their own tax liabilities. And timing can be critical here because these instalments are based on your last filed tax return. If your client or the other side is on an upward income trajectory, for example, you might act for a medical practitioner who's just attained fellowship or a barrister in the first few years at the bar. It's entirely possible that their prepayments of tax, which are of course based on their prior or most recently filed income tax year, it's possible that those prepayments are significantly less than what their current year's income tax will actually be. What this might mean for your client, for example, is that their bank accounts look like they're sort of flush with cash because they're not paying an accurate amount of tax on a fortnightly or monthly basis in the same way that a salaried employee would be. So I would suggest to you to be careful and ask what the instalment amounts are that are being paid, and how their income is tracking, as compared with previous years. And of course, the same applies in reverse. Someone might say, oh, we've got to pay a large quarterly instalment, but you can vary those in a number of different circumstances, which can really help from a cash flow perspective. And as I said, look, I would say this is less common, but it might be the case that someone is paying PAYG instalments at a rate that's greater than their ultimate tax liability. The effect of that is to kind of use the ATO to stockpile cash that will be refunded to them upon the filing of their income tax return in the relevant year. So be alive to that too. Another category you need to consider when thinking about income tax is top-up tax on retained profits of a company. We hear this word a lot, top-up tax. It's to set the scene, it's sort of not uncommon for our clients to have a basic proprietary limited company and hold the shares personally rather than incurring the cost of setting up a trust to hold the shares. If these companies have undistributed profits, you might find the other side wanting to include those retained earnings as an asset on the balance sheet. You get the financials, you see it there, retained earnings. If you're acting for that shareholder, it's very important to recognise that in order to do anything with those funds, for example, your client wants to use them to buy a house if the other party's retaining the former family home, we need to recognise that that money, if it's to be actually taken from the company, is subject to an additional tax burden. The actual calculation can be pretty complicated, but it broadly looks to the difference between what rate the company tax has been paid at and the individual shareholder's marginal rate that they'd be paying on the dividend that would be paid out of the company in order to get your hands on that money. So it's usually around sort of 22, 23% if you're dealing with someone on at the highest marginal rate. The other scenario in which top-up tax comes into asset pools is where the parties have existing Division 7A loans that need to be managed from year to year. And the relevant case here is Rogers. We commonly see this with businesses. So the main asset in a lot of cases where there's a significant business is the business itself. Often both parties work in that business and only in that business. It's run via a proprietary limited company. Often the actual shares in the company, as Kat said, are held through a family trust. So instead of being individual shareholders, it's the trustee of the family trust that owns them. But you typically see no one in the company is earning a salary of more than about $45,000 per annum, maybe up to 60 by way of salary, because once you get above that 16-cent marginal rate, other structures become more attractive. Sometimes people aren't paying themselves anything at all. Commonly, the parties spend the funds in the business bank accounts as though the money is theirs, and a bookkeeper sorts genuine business expenses, which can be claimed as legitimate deductions against income of the business, and sorts those separately from personal expenses, which are debited to a running loan account. We see a lot of this as family lawyers. So in order to meet the minimum instalment due on these Division 7A loans that are often kind of rolling loans from year to year, to meet those in any particular year, the parties either need to find the money from a source outside the business, which is often just simply not available, or a dividend has to be paid to the relevant party of at least the amount of that minimum repayment obligation so that the same amount can be repaid to the company. And it's the top-up tax on this repayment amount that becomes an immediate liability, essentially, that needs to be paid within 14 days of lodging that party's personal income tax return. If you're acting for the party who's retaining the business structure, it's a good idea to ask the accountant for the business to do you a calculation of what the next 3 to 5 years of top-up tax on minimum loan repayments will look like. particularly if it's common ground that both parties benefited from the loan accounts. That's how the mortgage got paid, that's how the private school fees were being met, and that the tax structures within the business have resulted in essentially there being more assets available outside of the business than otherwise should be the case, then you typically can argue that that tax, whether it's 3, 4, 5, sometimes I've argued up to 7 years, the top-up tax on those minimum loan repayment amounts is tax that ought to be recognised and included in the balance sheet as part of your overall property settlement. We know from the full court decision in Rogers, 2016 decision, that there's no requirement to necessarily take a calculation of future top-up tax off the top or include it as a specific liability on the balance sheet. And Shinohara would probably have some things to say about that approach in any event. The trial judge in Rogers didn't do this, and the full court found no appellable error in that approach. Just a percentage adjustment was made instead. But we do know from Rogers that a judge who ignored top-up tax in this sort of a scenario completely would fall into error. So making the argument in your client's favour is well worth it, and I would suggest certainly worth the cost of engaging an accountant to provide you with those calculations. The second last point on the slide about a Division 7A liability if payment to an exiting spouse is sourced from a company. This is a really important point if you are acting for the party who is exiting the business or the corporate group. And it alerts us to potential Division 7A liabilities. I would suggest, particularly if there is a corporate beneficiary, a bucket company, that's the obvious source of funds for a cash payment being made to your client, the last thing you want is the commissioner coming along and determining that the company made a financial accommodation to your client as an associate, and for that payment to constitute a deemed dividend. And there's an example a bit later in the presentation I've included where we can turn our minds to an appropriate indemnity in those sorts of cases. Finally, just want to touch very briefly on unpaid tax obligations for businesses now that we've seen the ATO's stance on this in recent years. We know that unpaid business tax basically doubled over the COVID period, I think for the 4 years from December 2019 to December 2023. Businesses just didn't lodge business activity statements or BAS, and instead retained PAYG withholding, GST, and often super guarantee amounts to try and basically stay afloat. And what we've seen in the last couple of years is a rapid increase in the number of directors' penalty notices, DPNs, being issued by the ATO. And as we know, these have the effect of holding directors personally liable for unpaid company tax debts in certain categories. So what this can mean in a family law matter is that one party can discover, really for the first time, that tax obligations that they thought were being met will in fact erode their personally held asset base. And this can be pretty problematic if one party is diverting business income to personal expenses and perpetuating that cycle. Legal fees is, I would suggest, one of the most common categories. So beware the DPNs and their effect on what you might think are safeguarded and personally held assets. I'll hand to Kat for the next slide. Sorry, Dina, you've got a question.
Before we move on to the next slide, you were talking about when a party spends sort of just through all their personal expenditure goes through the business account. What do you do when you're trying to prepare the client's financial statement? How do you capture that personal expenditure? Or is that something that the bookkeeper should be doing?
Look, it's a good question. Some people's running balances or ledger balances in their loan accounts are more up to date than others. So a lot of the time it's not sufficient to go through just someone's personal bank accounts. You do need the company credit card statements. And it really is a case of understanding, well, what are we seeing on those statements? Just because it's a business credit card doesn't, and often, solely provide for business expenses. A lot of the time you see a kind of 70-30 split. Everyone has an Apple Wallet. Everyone just has essentially company credit cards on their phone. But it is really important. I would suggest reviewing the actual vendors who is being paid money from company accounts. If they are not suppliers, creditors of the company, they are personal expenses, and they all of those should appear on your client's financial statement. The difference, I would say, if there is, for example, a phone or a car that is in the name of the company that is used for mixed business and personal use or benefit, I think it's important to recognise I have a company mobile phone and I have a personal use component, and often there's an apportionment. 70-30 is a common one I see. So that you are recognising I have a personal use component benefit of what is otherwise a corporate or company asset. Does that answer that question?
Yes, it does.
Beautiful.
Okay, so I think you said on to the next slide now.
Lovely.
Yes, on to CGT now, and a high-level discussion of duty. So still continuing on with the income tax point, and really the first point to make about capital gains tax is that it really is a misleading label, because it suggests that capital gains tax is a separate category of tax or a special kind of tax, which is not the case. So rather, if a person experiences a CGT event, all or part of that capital gain form part of that person's assessable income and must be included in their income return in the relevant financial year. So capital gains tax is really just a component that forms part of a person's own personal taxable income. It slides into the income tax return, that the capital gain, and forms part of that person's taxable income for that financial year. So generally the transfer of a CGT asset that was acquired post 20 September 1985 being another magic date, and that's when really capital gains income became taxable. So if you have CGT assets before that date, they won't be subject to that regime. But a lot of assets, most assets we deal with obviously are post that date or capital assets. So the transfer of those CGT assets or disposal will trigger a CGT event, and the possibility of a capital gain for the party transferring the asset, so the legal owner of the asset, as they are the party disposing of the interest in that asset. So the transfer of real property or motor vehicle is probably where it most commonly arises in a lot of our matters. And the transfer of real property or vehicle will also trigger a liability for duty for the party receiving the asset. And actually there are CGT exemptions for different kinds of assets as well. So CGT is as separate from stamp duty, but there will be duty often payable for, duty will be triggered on the transfer of an asset. So of course that's not the end of the story. So we know that subdivision 126-A of the 1997 Tax Act, broadly speaking, provides for CGT rollover relief for transfers involving a spouse or former spouse, commonly referred to as rollover relief, as I said earlier. But we know from a recent, although it's probably not so recent now, 2018, high-profile case that went to the full court of the federal court, that the party receiving that asset must be an individual for the rollover relief to apply. So this was discussed and held in the case of Allison and Sandini, and the citation is there on the slide. And this case looked at, amongst other things, what the word involved meant in the context of a transfer involving, transferee and transferor. So in the Allison case, kind of at a high level, the parties had final orders providing for the transfer of some shares in a listed company that were held by a trust controlled by the husband to the wife as part of the settlement. However, when the actual share transfer form came to be registered after the final orders were made, the wife asked the husband if the form could be signed in favour of a trust she controlled, and the husband agreed. So very nice and amicable, it sounds like, but created a lot of issues for both of them. So effectively, the shares were actually transferred from the trust in which they were held, the husband's trust, to the wife's trust, instead of to the wife personally, as the orders had provided. So when the wife sold the shares some years later, she was then initially assessed to pay a significant amount of tax arising from the capital gain on the sale, because the parties had established the company and listed it. So in fact, the cost base of the shares was next to nothing, meaning that when they were sold years later, the capital gain was enormous, as the cost base was almost nothing. So the capital gain on their sale was significant, and there was a significant tax bill assessed. The wife argued, however, that the liability should in fact rest with the husband, because the relevant event, she said, occurred when he transferred the shares to her trust. The ATO agreed and then assessed the husband at the point in time that when he transferred the shares to the wife's trust. So there was an argument really between the parties as to when the taxing point, did rollover relief apply and a deferral of the taxing point, and did the wife, take those shares really, pregnant with that, as we say, CGT, or was the taxing point when the husband transferred the shares to the wife's trust in accordance, or what they thought was in accordance with the orders. The husband tried to argue that the wife was sufficiently involved in the transfer, the word involved, in directing the nomination in favour of her trust, which would have meant, of course, that the rollover relief in 126-A applied, and there would be a deferral of the taxation point. But ultimately, the husband was unsuccessful in having the liability overturned. So the case is a really, really important one to keep in mind anytime you see a transfer of a CGT asset, whether it be property, shares, etc., going to any other entity or person other than a spouse party personally. So that should start throwing up red flags. We've often had matters where clients say, I want that house to be transferred to my company, or I want to take it. I had one where, the wife wanted it in her name and her sibling's name as well as part of the orders. And it needs to go to the spouse party personally for the rollover relief to apply. So a really important thing to be mindful of when you're drafting orders and looking at transfers to parties that are of capital assets that would attract CGT. So if not, if it goes to another entity or trust or another party that's not a spouse party, it may be that rollover relief does not apply, and then a taxation event will arise at the time of transfer.
And just to confirm, that situation wouldn't change if the, I guess, the trustee company had been joined.
Had provided for it. Yeah, really interesting. The case actually looked at both those arguments about whether if the orders had provided for a transfer to the trust and not the wife personally, whether it would have, been compliant with the section, and that was where the word involved was looked at. And the short answer is no, it wouldn't have changed. Yeah, so it has to go to the spouse party personally. Did you have anything to add, Liz? I know you had your
You've covered it perfectly, Kat. It's I think there are lots
really
of creative ways that people tried to get around that case when you read the judgment because of the quantum of the liability. Plus, it was a long time ago because the shares had been held for a long time before they were sold and the CGT issue arose. So there was there's always the argument about interest and penalties as well. So lots of creative arguments, but
yes.
The court said no.
And one that I think often is even, not picked up by, people advising on orders, outside the family law space, including accountants that may not be familiar with the family law or the rollover relief provisions, etc., that we deal with a lot. When they're suggesting things get, transferred to other entities or other parties as part of the suite of orders, really important one to, it's not necessarily wrong, but it just, not necessarily wrong to transfer and, have a CGT event arise, but it needs to be known by the parties and they kind of are entering into it with open eyes. And if they want to try and take advantage of the rollover relief, then it needs to go to a spouse party personally. I think that's us next slide, Dina, which I will hand over to Liz.
Thank you. So this slide's just going to briefly touch, just wanting to make sure we leave enough time for questions and some examples. If property is held in a trust, it's held within the corpus or the body of the trust. And a transfer of this sort of property is usually what we call a capital distribution, not an income distribution, which doesn't trigger payment of CGT if it is distributed to a beneficiary of that trust as part of family law property settlements. So many of our clients hold real property in discretionary trusts. It makes great tax sense to do so. If your client doesn't, however, want the sort of compliance burden or complexity of conducting that trust going forward, or just doesn't trust the baggage, that might come with a trust that the other party's been administering, but does want to keep the property itself, then a transfer from trust to beneficiary in their personal capacity could be a good option. And as Kat spoke to, we do know from the Ellison case, you can't go the other way. You can't hold the property personally or in a trust and then transfer it to another trust, even if that second trust is exclusively controlled by the receiving spouse. I think there was a special leave application in the Ellison case to the High Court, which was made but declined. And so really until or unless another test case comes along that's doesn't sort of suffer from some of the deficiencies that were identified by the full court in that case, we're sort of stuck with the reality that of the sub-dot points made on the screen, on the slide, only the first two are really permissible. I'm only going to touch very briefly on the transfer of assets from SMSFs to beneficiaries of those funds. It's a pretty complex area that requires specialist advice, but I guess the take-home point is that there are what are called exempt current pension income provisions that apply if your client wants to retain an asset outside of an SMSF, as long as that beneficiary's interest is in the pension phase. If they're still accumulating super, that's pretty unlikely to be available to them. But if you've got an SMSF in the pension phase, ask your accountant about the ECPI regime and see whether that is one that might be available. Thanks, Dina.
Okay, so in the last section of today's presentation, as Liz mentioned earlier, we wanted to share some practical examples of some really common scenarios that might confront you and your clients, which careful drafting or planning is required to protect your clients. So the first, again, in relation to CGT, it's an issue that arises in many of our property settlements. So in terms of whether it's included as a liability, so we know the test for whether a contingent liability is included as a liability of the parties comes from the case of Rosati. In this space, again, although Shinohara probably does have something to say about that as well, and we're all very keenly and closely watching that space too. But if the sale of an asset is inevitable or likely to occur in the near future or as part of the orders, then the anticipated CGT liability or the tax that will be assessed to the parties referable to a gain on the disposal of that property will become relevant when considering the net value of the asset. If there is a risk that an asset may need to be sold in the short to medium term, the court may take this into account now under section 79.5 or 90 SM5. However, the question of whether or not that liability or potential future liability should be recognised, however, is quite different, of course, from the practical question of whether cash funds should be quarantined for this purpose or placed immediately in the hands of the person in whose name the liability will arise. And your client's views about this question might depend on whether they're the legal owner of the asset or not, and in whose name the liability is ultimately going to arise in and be assessed to. So it's not uncommon, for example, for a party to seek an additional portion of sale proceeds to account for the estimated tax that might arise down the track on the disposal of that asset. But typically the liability won't be payable for many months following the lodgement of their income tax return. So it's not a liability that crystallises immediately. So just as an example, if parties are selling an investment property that they know will attract a capital gain, we often see orders that provide for the payment of capital gains tax in the cascading series of orders. So, and we thought we'd give an example that we really do see quite often in draft orders, and that say something like they have those cascading set of where the the manner and priority in which sale proceeds are paid. So for example, you'll see they say something like, first to pay the costs and commissions, second to pay the discharge, to discharge the mortgage, etc. And then often, they might say third to pay the capital gains tax, and lastly to pay the parties X%. So drafting like that can actually pose a significant problem, however, because as you'll recall from earlier in our presentation, capital gains tax is not a separate tax. So rather at a high level, the capital gain realised on the sale of the property is recorded in the personal income tax return of the legal owner of the property and discounted by any relevant discounts like the 50% 12-month holding discount, etc. So it means that the tax that will be assessed referable to that gain doesn't actually arise until that individual files their tax return at the end of the relevant financial year. So, for example, if the contract was entered into and the property was sold in, early, July or August 2025, for example, the tax liability would not arise until that person's return was lodged the following year, the end of the financial year, which could be as late as October 2026 for an individual. So the net sale proceeds, if the orders are drafted in that kind of cascading series that provide for the payment of capital gains tax before anything further is released to the parties, may pose a significant issue to the parties in that there is no capital gains tax that is actually due and payable. So it kind of freezes, they're frozen until the liability arises, and it doesn't crystallize until the end of the relevant financial year. So it's therefore, we would say our preference to include orders that contain a lot of detail around the payment of this capital gains tax liability and generally the setting aside of funds pending the lodgement of income tax returns so that money can be distributed to the parties and enjoyed by them in the meantime, but with the assurance that there's actually going to be money there available to pay the ultimate assessment when it's issued. So often we like drafting orders that provide for obtaining independent advice in writing for the estimated amount of tax accessible to each party or the party that's the legal owner, referable to the net capital gain. We often define this, for example, as the accountant's advice in the order, and this is really important, especially if a small business is involved. Sometimes parties are arguing over how to pay a liability that might actually be negligible if they qualify for very generous small business capital gains tax concessions, for example. But effectively, once we know the sale price of an asset, an accountant can give a pretty good indication of what the estimated tax to be assessed to the parties on any gain referable to that asset would be. And then the orders can provide for an amount to be effectively quarantined, taken out in the amount of the accountant's advice into, for example, a controlled monies account or a trust account, interest-bearing trust account in the parties' joint names, which will ensure the money isn't spent by either party in the intervening months, and there's something there to pay the ATO when that liability arises. And then when those assessments are the income tax returns are lodged in the relevant financial year, the order should provide for each party's respective notices of assessment for that relevant financial year and copies of their income tax returns to be exchanged so that they can each confirm the others, assuming, say, they were both joint proprietors of the property, which means they'll both be assessed on part of the gain, together with a letter from their accountant to verify the amounts sought to be paid. We like to call this in the orders, for example, the CGT confirmation that each party exchanges, and it may be a different amount because depending on the party's marginal rates, they may be assessed to pay different amounts of tax given their other taxable income that they've received in that financial year. And then the orders can provide for the parties to direct the holder of those trust funds, say the law firm, to pay the ATO directly from the controlled monies account in accordance with those notices of assessment issued. So it's a really kind of nice practical way to ensure that some money is quarantined for that purpose, and then the orders can provide for any amount that might be left over, because sometimes the accountant's advice is just an estimate that can be anything left over can be distributed, for example, in equal shares or however the orders provide for it. So this is often preferable, the last point I'll make on the indemnities point, that the direct payment and kind of setting aside of funds in most matters is often preferable to, say, a clause that says, party A will indemnify party B in respect of the tax assessed on the gain, etc. Basically where you're relying on the other party to pay your client's tax bill, for example, when it arises. The tax may still be assessed in your client's name if they were the legal owner of the property, and then you effectively have to chase the other party to effectively reimburse or indemnify your client. And indemnities are only as good as the people giving them. So there's no guarantee that, and it costs a lot of money chasing money, as we all know. So often putting it aside when it's there and available from the net proceeds, for example, is a much preferred approach.
We've just had a question on that point. So the question is sort of to the effect of when you're in the negotiation process and you're dealing with assets that are fluctuating in value, how do you manage that? The tax risk? Is it something that you just need to keep being aware of, keep updating the advice, or what advice do you have for the practitioners listening?
In this context, if we were talking about getting advice, an accountant's advice on an asset, on the likely tax, it would really only be the most appropriate time would be after the sale of that asset. So once a contract is entered into, the purchase price or the sale price is known, then they can give a really good estimate on what that may be. Sometimes we get advice earlier. You might have a range that a property, for example, because it's probably the easiest example, a real property, you generally know what it may sell around. But often in terms of the actual drafting of orders, it's the accountants will be able to look at the range and give an estimate, but when we're actually putting it in the orders, ideally the property would be sold. If it's not sold, hopefully you'd have an idea of what the sale price might be, and ultimately it's the money's going to be there from the net proceeds. It's a bit of it is what it is sometimes. It has to come out, but you don't have to know that amount before the orders are entered into. Does that kind of answer the question?
I agree with everything that Kat said. To that, I would probably also add, if there really is significant uncertainty or volatility, sometimes in fact, I think Kat and I have done this together, we've provided for a buffer of sort of between 5 and 20% above that accountant advice amount. So whatever the accountant advice is, you quarantine an amount equal to 110% of or 120% of the accountant advice, and that goes into the CMA. And then you provide for basically a refund in the same shares in which the parties are receiving their ultimate property distributions and entitlements, which, look, from a cash flow perspective, can be a bit annoying because, as Kat says, it can be like months, 12, 16 months after a CGT event before the actual due date for the lodgement of the return. So you're tying the cash up. But if there is that concern about volatility in sale price, and as Kat says, if you can't do it when you actually know the contract amount, then you buffer it.
Yeah. And I think the way you approach it might change depending on who you act for. For example, if you acted for party A and they weren't the legal owner and party B was the legal owner, and say party B had the funds and had the business or whatever it is, and you might not necessarily need to put in very, very complex provisions for quarantining of capital gains tax or the estimated accountant's advice, because the liability is not going to be assessed in your client's name. And that's not to say it's not factored in the settlement. Of course, it's factored, but in practical terms, the ATO will chase the party who is, legally assessed to pay that tax, and not look at the orders and say, oh, but it was meant to be half shared. Or so your approach might depend on whether the property is held in joint names and both parties need to come up with an amount, or whether it's held in your client's name or the other party's name. If it's held in your client's name and your client's going to be assessed to pay, and they have to include the gain wholly in their income tax return, then absolutely you would want money set aside. And if it's same if it's in joint names. But yeah, sometimes how you approach it might depend on how which party you're acting for and where the money's coming from, and if you're concerned there is or isn't going to be any there. And I think we have one more slide and potentially 3 minutes, so we will.
It's a great segue, actually, because the last slide, we're just going to very briefly touch on indemnities. I'd need to give you 10 slides to give you example indemnities, and even then it probably wouldn't even cover what you'd need in any given week in this jurisdiction. But thinking about our general indemnities for tax is very important to include in our final orders. If you're acting for the exiting party, which is kind of where it becomes almost the most important, think about the following for your indemnities. First, you need a relevant definition of tax. This will look different in different scenarios, but think about what it is that your client could be dumped with. Like, what is the mischief that you're trying to prevent? Craft your definition of tax accordingly. If we know there's going to be tax because people have been sort of non-compliant for a period of years, if an indemnity is intended to cover tax, penalties and GIC, the general interest charged by the ATO, state that in your definition. Be really careful about how you define it because, as Kat says, the ATO is going to chase whoever the assessable, the notice of assessment arises. So the second point is to make sure that your indemnity is directed to a party personally and, if it's needed, in their capacity as director of a relevant company, including a trustee. So from an enforcement perspective, think about whether you want or need to join a company. If you don't have orders drafted that require a person to do an act or a thing within a specified time frame, and if you don't specify in which capacity the person is doing that thing, if you choose not to join the company, you run into enormous problems when it comes to enforcement. Now, enforcement's happily not that common, but when you need to enforce orders, the scrutiny about how they were drafted has never been greater. Keep the exiting party indemnified in respect of loan accounts in either party's name. This is a really important aspect. We typically do this, we draft it in the form of an assignment. So it's things like the wife forthwith assigned to the husband at his expense, all debit and credit loan accounts in whatever the relevant definition is of your corporate group. Make sure you cover all tax assessed to either party or the company group, provided that that income that's received or deemed to be received emanated from the group. So, you know, your classic case where someone's been receiving paper distributions, make sure that that tax is covered, but only that tax. If you're acting for the party who's going to be paying the bill, make sure that if they go off and earn a job that you weren't realising, or they start a small business, you don't want your client on the hook for that tax. It's just the tax that emanates from your group. Cover all tax assessed to either party in relation to Division 7A. And if you do, frankly, if you do the prior dot point properly, you wouldn't need to rely on this point, but you add it in for completeness. And lastly, extend indemnity to any tax, howsoever arising from the manner in which the retaining party chooses to source or give effect to the payment to the exiting party. This is sort of, I guess, coming from a point made earlier in the presentation, really important. If the only likely source for a cash payment to the exiting party is the group itself, you don't want your client with a potential deemed dividend problem when actually they should have been receiving, and the orders provided that they receive, a payment from their spouse or former partner in their personal capacity. Dina, we may run out of time for questions. I apologise. It's 5:01.
That's all right. We did sort of address the questions as they came up. If anyone has any follow-up questions, feel free to email them and I might ask our presenters to answer them if they don't mind. But with that, so let me move on to the next slide. We have another webinar coming up tomorrow afternoon at 4 p.m. It's with Dr. Heather Gann of the Relations Space. This is part 2 in our series on complex issues in family law. So now we're turning to complex issues in parenting matters. So Heather's going to be looking at borderline traits in the context of family law proceedings and sort of how to manage those personalities. And then we've also got another webinar next Wednesday, which is Drew Cowan, also of the Relations Space, and he's going to be looking at autism and ADHD in the context of family law proceedings. Please do go ahead and check out our forum. The slides and the recording of this webinar will be made available in the coming days. As I said earlier in the session, if you have any particular topics you want to hear about, please do reach out and let us know. We're more than happy to work with you. And we'll see you at the next webinar. Thank you.
Thank you, Dina.
Thank you. Thanks, Dina.